Okay. Now, suppose you have to remember the fees. What you have to do, identify the relationship between the fees. What are the relationships? First, please remember numbers. You can write it down. The first number is form with no fee. The number of form with no fee is 3, 5, 7A, 26 to 29. That's it. From 26 to 29, no fee has been prescribed. 3, 5, 7A, no fee. Right? So out of 30, 6 forms are out. You don't have to struggle now. Not 6. It's around 7 forms. Right? Now you will come to another one. Another one is 7 to 21. You remember 7 to 21, the fees will be 2,400. Okay. Except now exceptions you have to remember. 7 to 21, 2,400. Except in cases of form 18, 18A, 13, 16, and 8. Read it with you. 8, 13, 16, and 18 and 18A. Okay. So 8, 5, 13, 13, 3, 36, 16, or 13 plus 5, 18. Howsoever you want to remember, you can remember. Right. 8 plus 5, 8 plus 5, 13, 13 plus 5, 18. ये आपको बोलना, there is a series. 8 plus 5, 13, 13 plus 5, 15. So this is the fees. For these fees, 2,400 is not the fee. What is the fee? You remember it separately. For these fees. For these, you have to remember separately. For example, 18. 18 is 4,000. 18 is, sorry? Okay. So for 18A,
8,000.
8,000. 8,000. Correct. And if there is in 18A, if request for examination is already filed and expedited is later on requesting, so the difference of the fee is 4,000. That is 4,000. So simple. You have to remember this thing. 7 to 21, 2,400, then 8, 13, 18 plus 16. You cannot forget, you will remember that. This is the fees on which 2,400 I don't have to write. 1 to 5. 5 is a declaration of inventorship, right? It will not have, this we have already discussed, no? Mention of inventor, no fee. 3, 5, 7, 8, no fees. Then comes 4 will have fee, 1 and 2 will have fees. 1 is 1,600. Now you remember how many fees are there which are 1,600. Patent application, amendment of a patent, and registration of assignment, license, transfer of right. 1,600. That's it. So this is how you create some, you bring actually some reasoning in remembering the fees. That's all. The claim one, though, you have to remember, questions are asked and you might have to tell. So please remember, in 2, there is generally no fee up to 10 claims, 30 pays. 10, 30. 10 claims, 30 pays. 30 pays. Per claim, it is 320. Claim is costful. So it is 320 per claim and 160 per page. And if it is sequence of nucleotide, 160 per sequence, per page. Again, additional fee for sequence of nucleotide, 160 per page. But if it is sequence of nucleotide, your maximum will be 24,000. That is what a cap is. And if you remember, I'm talking about only individual fees. And in this, 160, 1,600, 8,000. If you see, everything is multiplied by 8. 2,400, right? And this is 80, then if you go by this is individual's fee. If you want an other entities fees, How will you get it? 5x. इसका 5x is other entities fees. And these two are e-filing fees. If you want more than that, suppose you want to go for this filing fee for in offline mode, then 10% increase. General concept, 10% per more increase will give you the offline fees. So now you can guess, you can remember without any problem. So this is how you will do fees remembering. So first section and forms. From form correlated with fees, and your three major things have done. Now go for timeline part. Timeline part, when you are remembering two things. What is the period and from where it starts and where it ends. Some places there is a date of filing, some places there is priority date, or some places date of filing plus or priority date. Third part, what will happen is, when you are remembering, you have to remember simple notice. Sends either dispatch will be the milestone from where it will start, or it will be the you can say where when you have received. These are the only when applicant has received the notice, from their timeline starts, or from when controller dispatches, then notice starts. This you have to check. If you remember this, your timeline will not go wrong. Everything will follow. Most confusion happens from the time, from where the timeline starts. You miss it. And I can assure you, with timelines, you can get at least 4 or 5 marks directly or indirectly in the paper. Timeline will always be crucial. Suppose you are describing an apposition process, then also the timeline is crucial. If there is a direct MCQ, then also timeline is crucial. So everywhere, and with respect to PCT and other filing, there is a clear-cut timeline question in MCQ coming in the paper 1 also. So please focus on timeline. This is what you are remembering, and what you will do. Whatever you have learned today, you have to revise tomorrow. Please don't say that in the last I will revise everything in one go. No, you will mess it up. You revise the first thing which you have revised today. What you have learned today, revise tomorrow. On the third day, revise both days. Then another fourth day, revise 3 days. Revision will take more time now, but your speed will be slow. But what will happen is, regular revision will consolidate your law, will consolidate your sections, because of which you will not get confused there. You will not get confused with the particular array isme 1 or 2. So the MCQ questions which comes 3, you will not get confused. So, or when you are writing, it will strike exactly where you are going wrong. So please start learning, and with learning, most important is revising. All those people who are forgetting is that they are not revising. See, when you start eating, what you do? Spoon by spoon, right? 1 spoon at a time. You don't keep pura ek saath khalo. And when you are being served, if you are being served little and little, you can eat more. You can digest more also. अभी पूरा कुकर सामने रख देगा तो क्या खाएंगे? Right? तो वो problem आती है कि you cannot have everything in front of you. It creates stress. कि how will I cover? So you start covering it now. Start working. From today, you make a rule that I will revise daily. Whatever I can read, I will revise, and next day I will add something more in there. See, 150 sections, 10 sections per day. In 15 days, your course is finished. If you go with this. including the rules. 10 section you are learning. So there are few sections which are very small. There are few sections which are very huge. But that doesn't matter. What I'm saying is keep on piling on, keep on aggregating it, keep on adding to your knowledge every day and revising it. If you are revising it, you will not face the problem in exam. One thing. Second thing, start practicing. All of you, you might be very good in understanding and phrasing this, and you are very good in English. But please, in stress, everyone makes a mistake. So start writing. Give 30-minute practice daily at least. And when I say 30-minute practice, this 30-minute practice will include your drafting. You go with 30 minutes. See, as I discussed with you, you will get 30 minutes and 45 minutes to draft the sections. 45 minutes for 30 number questions, and this 20 mark question, 30-minute questions. I am keeping 30 minutes as a buffer, which you will be anyway utilizing here and there where you are not getting time. So consider this as a 30-minute exercise and practice in identifying the invention, drafting the claim, writing the abstract and title in 30 minutes. That's it. Not more than that. In 30 minutes, you should do this. Because whether it is 20 marker question or a 30 marker question, you have to write these three things. Any title, abstract, and claim. So practice title, abstract, and claim at least. And more, and always practice with a stopwatch. Stopwatch puts pressure on you. It says that now, if I don't complete it, what will happen? This is the same kind of a stress which you will be feeling in exam. You see, those who run a marathon, they don't run in one day, right? They practice daily. The more and more you practice, better you will be. Start practicing from today. This is high time, nothing else. You start doing it. Even 30 minutes per day will change your attitude. 30 minutes revision every day will change your confidence and you can say the hold on your subject. So use 30 minutes in morning and 30 minutes in evening. This is the only two things you have to do. You are traveling, you are going in auto, you have time. Go through these things in those time. Those are the spare time where you can always think form 1 means what, form 2 means what, form 3 means what. That is okay. Fine.
Okay.
So okay. Let's start with the today's session. See now the procedure for grant of patent we were discussing. We have discussed that how the novelty is being assessed, what are the exceptions to the novelty, those anticipation and other things. Now we are talking about how the power of controller with respect to patent application works. There are two places where power of controller are given. One is here, another is later on, where they talk of in general the power of the controller. This power which we are discussing here is related to patent application. And then there are other powers. For example, the power, there is a power that they should be considered as a civil code. They can summon you, they can take evidence on affidavit. All those powers of controllers are in a different section. Let's start with today's section. The first thing is consideration of report of examiner by controller. You would be remembering that what happened in section 12. Section 12, controller refers that application to examiner and examiner has to investigate it. The investigation of anticipation, you will be remembering that it was a section 13 in which it was being investigated. Under 13 investigation, there were three major areas. First was the prior publication, that is that those documents who were published before the patent date of filing of the patent application which is being examined. Before that, those are the prior published documents and prior published patent document in India. Those, their specification is relevant, and by reading those specifications, this invention is being examined. Then we go to 13B, 13(1)(b). 1B was that with respect to the patent application which has been filed, though it was filed later than your application, but it has a priority date before your patent application. Hence, we are going to check its claim, whether your claim, your invention is being anticipated by their claim or not. Because of this, this format can be referred as a prior claiming. So I will talk about prior publication and prior claiming. 13B, when I'm talking about, that is a prior claiming. Then you go for third part. Third part was that non-patent literature in India, that is published as well as used, non-patent literature, and then go for another part, which was that patent literature as well non-patent literature, any publication worldwide. All that came into 13(2). So that was also a prior publication because they talked about before the date of filing of our application. This is what they taught. Okay. So from that 13, after the investigation, the report has been made. Now the report is referred to the controller. If controller sees that the report is adverse to the applicant, or it requires an amendment of the application, then what will he do? So before disposing of the application, he will communicate the objection, a gist of objection to who? To the applicant. This first gist of objection is called first statement of objection, FSO, or FER in a common language, that is first examination report. Then when you receive it, then at the same time, it says that you can also avail the opportunity of being heard. If you don't agree, you can also avail the hearing, and tells that within this period you have to respond or ask for a hearing. This is what the consideration of reporter, examiner, or controller 14 talks about. 15 says you can, if you think that this is a power, that there are two things he can say. First, he can either suggest an amendment. To comply with the requirements of Act, either you amend or refuse. That there is nothing which can be amended. So it will say on its face that it is refused. But if it can say that please amend to my satisfaction, means I am suggesting the amendment. If you are fine with that, go with this. However, what is the procedure then? You get the objections. After getting the objections, you might not, you are not happy with the objections. You have your own view. You will tell your view. You will give a reply to your first examination report, and then ask for hearing if required. Then he will go through the objections. If he is fine with whatever you have submitted, he is happy with that, and he is convinced, he will say okay. Otherwise, he will give you an opportunity to be heard. In hearing, you can again present your arguments in favor of your invention. If he is convinced, he will grant you. If he is not convinced, he will again ask you to either change or change it as per his direction. If you change it, he will approve. If you don't change it to his satisfaction, he has the right to refuse. This is what 15 power will talk about. Now comes 16. 16 we have discussed. There is nothing much to discuss. We have already read it. 16 talks about divisional applications, that if an invention has more than one invention, controller can raise an objection on this, that there are more than one invention. If that is the objection, you can remedy it by going for a divisional application. The moment you divide it with each invention separately, then the earlier filed application will become first mentioned application, and the divided application will become the divisional application. Both will have the same date of priority, and that's how it will work. And they both will be work as a separate independent patent once granted. So this is okay. Now comes 17. 17 also we have discussed. 17.1 talks about the post dating, and 17.2 also talks about the post dating. 17.1 was the post dating with respect to that any post dating should not be more than 6 months from the date on which it was actually made. And second, the post dating can be done by controller at the request of the applicant, subject to the section 9 provisions. Then 17.2 talks about that if application or specify any document is required to be amended under section 50, then if controller thinks that there is a requirement for me to change the date, so he will say that this date will be deemed to be made, this amendment has been made when that requirement has been completed. So that is your claim date is shifted. If you are amended a claim, that claim date will be shifted. That's how what he's talking about. See, this is the post dating. However, there was a question by Ananya on this. Ananya, not every time controller will ask you to do this. This is a power with him, but it should be exercised only with a caution that if you are post dating it, there has to be a reason for that. Suppose you have while doing something, you have introduced something new, right? Then he can say, okay, now this should be started from afresh because the same was not present earlier. That if you are within a scope and other thing, I don't think this kind of deeming provisions will be directed by the controller. Next comes 18. Power of controller in case of anticipation. This anticipation relation, please remember the investigation of anticipation was happening in 30. And the 18.1 is talking about 13.1a and 13.2. That is prior publication cases. That is the publication which have been referred are before the publication, before the filing date of the complete specification. Now, he is saying refuse. He may refuse to the application unless the applicant. He will refuse the application. If there is anticipation, he will refuse. What is your defense? Defense is you say that priority date of my claim is not later than the date of that relevant document which you are citing. Okay. That is when it was published. Priority date of the claim is not later than the date on which the relevant document was published. That means its publication date. That's how it is important. And then comes amends is complete specification, or you can amend it. If you cannot defend it, then you follow the instruction and amend it to the satisfaction of controller so that the objection of anticipation is addressed. Then comes prior claiming. Prior claiming is if there is a prior claiming, then what is talking about is that then you have to make a reference in that specification of that applicant's complete specification. He can direct you to that. If you agree to it, you can introduce the reference or you can defend it. Or that's how it is. The first defense is same, that you have to say that the priority date of his claim is not later than the priority date of the claim of the said specification. Your priority date is your priority date is earlier than the priority date which has been claimed, or on the same date. That also is not later than it is talking about. Not earlier than it's not talking. It's talking about not later than that. It can be on or before the priority date which has been cited. If that you can prove, that is a defense. Or you can amend, that is you can improve the reference as required by the controller. Then comes 18.3. 18.3 talks about the 13.1, the Indian prior publication, Indian patent prior publication. He is saying if there is again a claim, okay, that you have to, that claim is same to the is claimed in other company, this prior publication one. If that is their claim, then same thing. The reference should be given. The provision subsection 2 shall apply. That is, it should also be referred. However, you have a defense that you have to explain that the priority date of applicant claim is not later than the priority date of that specification. Okay. So please remember what is the defense here, and that defense will help you in address, because there can be a question that I have got this objection, how to address. Then you have to prove this. So you have to tell, okay, this is how this works. And since my priority date of my claim is not later than the priority date of the claim of what you have cited, so I should be granted the patent. Now comes 19. This is also similar to the same thing. Power of controller in case of potential infringement. If, in consequence of investigation required under this Act, it appears to the controller that an invention cannot be performed without substantial risk of infringement of a claim of any other patent. Okay. So you have to direct that a reference to that patent shall be by way of notice to the public. The applicant shows to satisfaction of the controller. Now, again, there are two places. Either you amend it or you say that there is a reasonable grounds to contesting the validity of said claim. And you can contest that claim. Then comes, if after reference to another patent has been inserted in the complete specification, but that other patent is revoked or ceases to be enforced, or that specification is amended by deletion of the relevant claim, or the court or controller has found that the earlier claim which was cited is invalid or not infringed by working of applicant's application, then if applicant requests the controller, the reference can be deleted. So this is the part of how controller works when the cases of anticipation, in the case of infringement, or in case when all the requirements of acts are not being met, how he wants you to comply. So simple thing is, he suggests you an amendment, he asks you some questions to some document which are missing to be provided, and that's how you do. In prior claiming or in prior infringement, what is the remedy he has? He will suggest you refer the cited patent or cited patent application. What is your responsibility? If it is a patent, you have the only one thing which you can do is claim that that particular claim was invalid. However, in patent application, you can always say that your priority date is earlier to the priority date claiming date of that claim. That's how you have a defense. Okay. Now comes power of controller to make order regarding substitution of applicants. See, substitution of applicant. What are the conditions where the applicant needs to be substituted? Any clue, any idea, anything which you think?
Yes, sir. A wrongful obtained.
Assignment of rights.
See, wrongful obtainment is, you will not ask for substitution. You will challenge the applicant status itself. Right? You will oppose that application. Now, what here I'm talking about, I'm talking of substitution. Substitution means that someone else is getting replaced here. So this substitution is different from that wrongful obtain. Substitution under 20 talks about two things. That the earlier applicant also has a right, but as we have discussed earlier, three ways right can be transferred. One, either by the agreement or by the operation of law or by the will, because someone dies. So there is only two scenario if we focus on this: if someone dies or someone assigns. These are the only two scenarios, or by an agreement. So he is talking about if a claim is made in a prescribed manner at any time before the patent has been granted by virtue of any assignment or agreement in right, or by operation of law, the claimant would approach, and then what will get? Controller will direct that his application should be proceed in the claimant name and in the name of claimant applicant or other joint applicants as the case may be. The first thing is that if you approach and you can prove that you will get you are entitled to the right interest or undivided share of the patent. Undivided share means simple thing. If you are a joint applicant, suppose there are three applicants, so since we cannot demarcate the lines, how much, which claim you own, which claim another person own, so we consider it undivided share. That is what undivided share of patent means. So this is how it works. Any assignment or agreement or by operation of law, if you are getting a right, you approach the controller and controller will direct that your name should be included. If there are, now first question is, suppose they are a joint applicant. So what will happen? So consent of all applicants is necessary. You cannot substitute someone's name without consent of all the joint applicants. Third talks about assignment or assignment agreement. I cannot take that assignment or written agreement of assignment unless invention is identified by the reference to the application number. That means suppose you are drafting an assignment agreement. What will you remember? You should always refer the application number. That is, it should be specific assignment with respect to that particular patent application. Then comes about there is to produce. Then you have to acknowledge the assignee. If assignee is there by the person whom the assignment or agreement was made. Okay. Or the agreement relates to invention in respect of which that application is made. So you have to get the acknowledgement of the assignee also. Assigner, sorry, assignee I'm saying. Assigner. Who is assignee? His acknowledgement should be there. The rights of claimant in respect to invention have been finally established by the decision. Or there can be a scenario where the court has said that he is also the rightful owner. So he can claim. Please remember, one who applies is called applicant, and one who is claiming a new right is a claimant. The controller gives direction for enabling the application to proceed or for regulating the manner in which it should be proceeded into section 6. So if there is a dispute and controller has reached a decision, then also this direction can be given. Section 5 deals with the disputes. Then talk about 4, where suppose this is only in death. Please remember, if someone dies, then what will happen? Its legal representative a request can be made by who? The surviving legal heirs. Those are survivors or survivor. And with legal representative of the deceased. That consent of legal representative is there, then controller will have no issues. He can direct that the name should be proceeded. So you have to submit the probation certificate or any other document which shows that how this legal they have become the legal heir. Now comes if dispute arises between the joint applicant for patent, whether or not, suppose there is a dispute arises. They are legal heir, not legal heir, whatever it is. Then all the parties concerned will have the opportunity to be heard, and after hearing everything, controller will give the direction how that application will be proceeded. This is how applicant is getting substituted during the process of patent patent prosecution. When the patent is getting prosecuted during the application stage, this is how they will be substituted. Now comes 21. 21 talks about the application to put application in order for grant. It says that if an application of patent shall be deemed to have been abandoned unless within such period, that is 6 months, prescribed period is 6 months, the applicant has complied with all the requirements imposed on him or under his act. Under this act, whether in the connection with the completed specification, otherwise in relation to the application, from the date on which the first statement of objection to the application or completed specification or other documents related thereto is forwarded to the. So the applicant should comply. FER I have issued from their date within 6 months. You should comply with all the requirements imposed on you by or under this act. Then, if in a case of a convention application or an application for PCT designated India or application for patent or registration, any document has been returned to you in course of proceeding, the application shall not be deemed to have complied with the requirement unless you have right-filed it. If you have written it, you have to refile it. Okay, unless the applicant says that it cannot be refiled. And the reason for not refiling are beyond the control of applicant. Right. So this is the only thing. If I have written something, you have to refile. If you are not refiling, prove that you cannot refile because the refiling cannot be done because of the reasons beyond your control. Then comes if at the expiration of the period, whatever, appeal to High Court is pending in respect of application for the medium. If there is an appeal, that is, there is a lispendence. Then comes in case of an application for patent of addition, an appeal to High Court is pending in respect of either that application or application for the main invention on the time within which the requirement of controller shall be complied with on an application made by the applicant before the expiration of the period as prescribed under this or extended. So what he is talking about, suppose controller has said something or something and you have gone for the application, gone for an appeal. Or in patent of addition, there is an appeal. Or main invention is under appeal. So what will happen is, what will you do? So either 6 months or the extended period as prescribed by the high, whichever is the later. This is how it will work. Suppose it's talking about suppose you are going to appeal, but appeal mention has not expired. Controller can extend it for further period as he may determine. Provided that if an appeal has been filed during the said further period, the High Court has granted any extension of time for complying with the requirements of the controller, the requirements will be complied within the time granted. Simple. If controller has extended earlier and later an appeal has been filed, then also you can get the extension. So that is application for grant. In general, time of extension of application to put an application in order for grant cannot exceed more than 3 months. Comes grant of patent and right conferred thereby. Now, how suppose controller says now it is in order for a grant and controller has not refused it and it has not been found in contravention of any act, then it should be granted as expeditiously as possible. And when it is granted, there will be a seal of patent office will be affixed, and date on which the patent is granted will be entered in the register. The date on which it is being registered, there will call date of recorder and date of grant. On the date of grant, the controller shall publish the fact that patent has been granted, and thereupon the application, specification, other documents related shall be open for public inspection. So once patent is granted, all the documents related to that patent are open for the public inspection. This fact will be published. They are publishing the fact. If you remember, I showed you the official journal, the published journal. If you go in those journal, if you go there, you can see that there is a line to this effect there, where it says that all those patents have been published, have been granted, and their application specification and other documents are open for the public inspection. Date of patent. Now come date of patent. Date on which the application for patent was filed. Every patent shall be dated as of on the date on which the date of patent was filed. That is filing date. That is considered as a date of patent. Date of every patent shall be entered in the register. Then, but you cannot claim infringement before the date of publication, because your invention was not known by anybody. So they cannot infringe it unless it is published. So before publication, your patent cannot be infringed, hence no suit or other proceeding can be commenced or prosecuted in respect of an infringement committed before the date of publication. After the date of publication, yes, infringement suit can be. Every patent shall be in prescribed form and shall have effect throughout the year. Correct. A patent shall be granted for one invention only, obviously, because one invention, one application is the rule. If suppose by mistake a patent has been granted to more than one invention, then then also it shall not be covered by any person in a suit or other person take any objection to patent or grant. It has been granted for more than one. However, no one can take that plea that this patent has been granted for more than one invention. Then come to 47. That is the grant of patent. Now, grant of patent is conditional. 47 is that. 48 talks about the rights, but conditions come first. Condition is simple. That government for his own use can use any patented article. When I'm saying patented article, I'm talking about the product, not the process. And patented article means machine, apparatus, or other article in respect of which the patent is granted, or any article which is produced by the patented process. So I'm talking about the product here. The product can be imported or made. Now remember, before understanding this, let's go to right. What is a right? Right of patentee is with respect to product is that no third party can use his patent without the consent of the patentee, and cannot do which act? Making, using, offering for sale, and import. Right? These 5 things: making, using, offering for sale, and importing. So these 5 things you cannot do if it is a product. If it is a process, same thing. You do not have this consent from the act of using that process and from act of using whatever has been used, act of using, offering, selling, or importing. For those purposes, the product obtained. First is you cannot use the process, as well as the product which has been obtained from that process can also not be used, sell, offer for sale, or imported. Okay, so this is a slight difference between process and product. And now we will understand how these conditions are an exception. See, we said making, using, selling, offering for sale, and import. The first thing it says that any patented article can be imported or made by or on behalf of government for purpose merely of its use. If government is doing it for its own use, then government is allowed to import, make the patented article. If there is a process can be used by or on behalf of the government for the purpose of only government use. Then comes the third part says, third part is a research exception, that any patented article can be used by any person merely for experiment or research as well as teaching, imparting instruction to the people. This is in research section कि हाँ मैं ये आप research कर सकते हो, you can experiment कर सकते हो, teaching, you can teach the students. Then if it is a drug, then again a medicine or drug can be imported by the government for what? Not only its use, because they are getting here, not merely for its own use or merely of its own use or for distribution in. So government can use as well as can distribute in any dispensary, any hospital, any medical institution which government maintains or on behalf of government which is maintained. So you can say public health hospitals, public dispensaries, or public medical institutions, or any other notified dispensary, hospital, or medical institution who are engaged in a public service, which are specified on behalf of notification. So please remember these exceptions, conditions, this way or that way. They have always been asked. The grant of patent is subject to what conditions? Either they create a case study on this or they ask it directly. They have done that. So this is a very important section. Then now we come to right of patent we have done. Now this section, there is another act which is not considered as infringing. What is not infringing? They are saying patent rights are not infringed when used on foreign vessels, etc., temporarily or accidentally in India. Suppose this talks about that. Please remember, vessels or aircraft registered in a foreign country. One thing. If there is a vessel, that means a ship or any aircraft that is of foreign origin, that is registered in foreign country, or any land vehicle which is owned by a person ordinarily resident in such countries comes to India. That means a foreigner or any person who is not resident of this country, he is driving a vehicle and he comes to India, including territorial waters thereof. Territorial water is the boundary. In sea also we have certain territory till which India's expenses there. We can exploit the boundary of India doesn't end at the land. It extends into the sea. To the extent it is India can exercise that its sovereignty on the sea, that part is called territorial water of India. So it is what? 3 nautical miles something. Just check. Territorial waters are some 30 nautical miles or something. I don't remember exactly. I have to check. So including the territorial waters are temporarily or accidentally. It comes temporarily or accidentally. Please remember this. Temporarily or accidentally is very crucial. Then says the right conferred by a patent for an invention shall not be deemed to be infringed when by the use of the invention in the body of the vessel or in the machinery, tackle, apparatus, or other accessories. If in ship, with respect to ship, what I am talking about, that it is used in the body or any machinery, tackle, apparatus, or accessory. What is tackle? Tackle means all rigging, crane, etc., which are utilized on ship to load or unload cargo. Those are called tackle. Now, so machinery, tackle apparatus, or other accessories, if there is, then till the invention is used on board the vessel or for actual needs only, it is considered as not infringed. One simple line here is, if a vessel is, in general, international law also, if there is a foreign vessel which has a different flag, we consider it as a different country's territory. We don't consider it our territory. So please, this also helps you in understanding that foreign vessel we will consider as a foreign country and their patent is there only. That's why it says used on board on that vessel and for his actual needs only. Or if you are constructing or working of aircraft or land vehicle or accessory there, and if aircraft and land vehicle get punctured here or get a problem where the repair is needed, then for that particular purpose, we are allowing that if patent is being used, then those patent rights will not be considered as infringed. This is what we have seen. Then we are saying another part. What is this? That this section will not extend to vessel, aircraft, or land vehicles owned by person ordinarily resident in foreign country who do not give this right in reciprocity to us. Simple. Agar they are not reciprocating it to us while imports are within their territorial water, then we are also not extending it. Okay. So this is the section 49. But now, a question was asked last year on this, and Ananya has requested to discuss the same. However, the question was very good. It has two parts. Please read. Can you see this? Now this. Karan, an Indian citizen, owns a shipping company in Visakhapatnam. Okay. Karan is an Indian citizen. He got a call from his friend, John, a US citizen. Okay, who also owns a shipping company registered in USA. Shipping company is registered in USA, informing that John's ship Discovery developed some technical snag while passing through Indian coast and needs urgent repairs. He requested Karan to get it repaired at his dock in Visakhapatnam. Okay. On inspection of the ship, Karan realized that technical snag can be repaired using the technology that is patented by Shiprep, an Indian company. The Shiprep's patented technology can repair such damages in few hours as compared to conventional process of repair which takes weeks. Karan used their technology to repair Discovery at Indian coast without the permission from Shiprep. After a few months, one of the ships owned by Karan also developed the same problem and Karan got it repaired using the same technology of Shiprep without permission. Shiprep came to know about such uses of patent technology by Karan and approaches you for expert guidance. What is your advice? So, first thing in this question is there are two uses. One is on a ship which is registered in US. Okay. Now, John's ship is foreign vessel here. While Karan is using on his own, although all his ships are Indian vessels. So, first thing which is very clear is Section 49 is not applying on the actions of Karan when he is repairing his own ships. Because section clearly says foreign vessels, aircrafts and land vehicles owned by persons who are not ordinarily resident in India. So second is very clear that Karan has gone for an infringement. Karan has infringed. Now, the first, so half question is answered. Now half question we have to check. Then in half question it says that 49 we have just read that foreign vessel, if on board that invention is being used, on board of this, and the ship is here temporarily or accidentally. Technical esclave, while passing through Indian coast and needed urgent repairs. It's only for a repair, and it was just for time being, and when it was getting repaired, ship will be repaired on board only. So considering that it was repaired on board only, the first action will have a protection of section 49, while the second will not. What will you do to shipwreck? Your advice is simple, that first, the chances are there is a clear infringement. Second, the infringement claim of shipwreck might not be accepted because of this rule of 40. This is the only answer which you have to write. Okay, any question on this? Ananya?
Got it, sir.
Got it? Okay. So, done. Now comes 49 finish. Now I will be going for grant, fees and maintenance. Just allow me. Okay. So second part is grant, fees and maintenance. Grant, once you are granted, patent is granted in the prescribed form in third schedule. This question can come. What is the form of, where the form of patent is prescribed? Third schedule. Patent certificate issued within 7 days of grant of patent. What is date of recorder? Recording in the patent register is called date of recorder. It is same as the date of grant of patent. What is date of patent? Please remember, date of patent and date of grant of patent are different. Date of patent is a date of filing of application. Date of PCT NP phase application, if that is the case, then we always consider date of filing of PCT international application as a date of PCT NP phase file application, not the date on which it enters the PCT NP phase or national phase. Now comes how the renewal fees are paid. See, when I discussed earlier also, I told the moment your patent is granted, now your obligation for compliance systems. First is the renewal fee and as the working statement. So first is payment or renewal fee. If patent is granted after 2 years from the date of filing, payment of accumulated fee within 3 months from the date of recorder starts, and period can be extended by 6 months. Means what will happen is you got a grant today or date of recorder, same thing, date of grant. Within 3 months, you have to pay the renewal accumulated fee. For example, if 2 years you got it in 4th year, then you have, since renewal fees are always paid in advance, you have to pay the accumulated fee for 4 years plus 5 years included. That one advance. Then your renewal fee will be happen. So this is the example. If patent granted before expiry of 2 years, first renewal fee will be due in the respect of 3rd year, but it should be paid before expiry of 2 years because renewal fees are paid in advance. Now, just for your understanding, I have just classified it because there is lots of entries with respect to this in the fee schedule. Please understand, since patent procedure generally takes 18 plus 6, 18 for publication and 6, it cannot be granted before 6 months. So this is the shortest time in which a patent can be granted if you have not requested for early publication. So this is 2 years, and then no fee has been prescribed for those 2 years because we are considering that anyway patent will be in the prosecution stage. 3 to 6 years. So it is 4 and then 5. 3 to 6 years, and then 7-10 years, and then the rest. It starts with 800. From 7th year, it gets thrice 2,400. Then again it gets double, 4,800, and in the last 8,000. So 800, then 3x, then 6x, and then 10x. Remember, 3 to 6 years, 2, 4, 4. The first 10 years finish, next 10 years are in 5 years. The 11 to 15 years and 16 to 20 years. Same things. So you can always remember it like this. Renewal of patent. You have to renew the patent within due date, or if you ask for extension, then extended period of 6 months. Before expiry, you should request for extension. Please remember, because once expired, what is there to extend? So expiry period can be extended before the expiry of the period which you want to extend. To renewal fee for patent of addition. That we already know. Annual renewal fee can be paid for more than 1 year in advance. You can go for payment of more than 1 year. However, if you don't go for, you can yearly pay them. Now comes the statement of working of patented invention and commercial history. Form 27 needs to be filed every financial year and within first 6 months of the FY. So by September end, you should file it. After the FY in which the patent was granted. From first FY, this FY if you are granted, then from next September, you should start. Before next September, you should file the working statement. And the statement of working, Form 27 is to be filed by patentee as well as the licensee. Everyone. Rule 131 and section 146(2) deals with it. This is the Form 27. Let's look at this. So please read this. Nowadays, they also go for this. Every patented, every licensee, exclusive or otherwise, is required to file this form where a patent is granted to 2 or more persons. All such patentees may file this form jointly. That means joint all patentees, not only one. All such patentees may file this form jointly. However, each licensee shall file the form individually. The patentees in one, all patentees in one, and licensee separate. Okay. And you have 5 patents, all patents should be done. Not one patent, one working statement. For all the patents, you can file. See, it says that one form may be filed in respect of multiple patents, provided all of them are related patent, wherein approximate revenue accrued from particular patent cannot be derived separately from approximate revenue value accrued from revenue. All such patents are granted to the same patentee. If all patentees are same, then yes, you can go for filing of multiple patents. So these are the procedural guidelines which are not provided in the rule but here. So please read form once so that you can identify these kind of a crucial elements. Now come. Now before winding up, I will talk about the common format of proceedings. See, all the proceedings in general in patent work in a same way. The steps are same, timeline might differ, timeline might be different, but steps are in general same. So if you remember this, so more or less every proceeding will work in this format. This is a general format. First is anyone, whether an applicant, claimant, patentee, anybody. In general, what happens is he gives a notice to controller. With notice of what? It can be notice of anything. It can be notice of opposition. It can be notice of for amendment, anything. So I'm talking about if anyone is starting a proceeding, we will see that in each and every place, these are the steps which are followed. They are strictly followed. And very few places there is a variation. So if you understand this, most of the proceeding you will always remember and there will not be a problem. So first is the notice. Who will you send the notice? You send the notice to the controller. Interest, ground, and evidence. These three things you have to tell in that notice. You have to tell what is your interest, what is the ground on which you are opposing, amending, revoking, whatever, opposing, anything, whatever you are doing, that ground, and plus evidence, whatever to support your claim which you are making in a notice, you have to give it to controller. And a copy of notice should be sent to applicant. Within 2 months, controller will, within 2 months, no applicant can reply to contest. And whom he will reply? To the controller. And when he is replying to the contest, he is replying, that means he is contesting. When you don't agree to particular thing, whatever is being claimed, we say that you are contesting that particular notice. So you are contesting. If you are contesting, what will you have to tell? Grounds of contest. Why you, on what ground you are contesting? What is your evidence? And you will send one copy to opponent also. That means you are sending it to controller as well. You are informing to opponent. Similarly, as the opponent has done, the earlier party has done. Now, the person who has earlier approached, we are considering him as an opponent at present. The reply by the opponent is now replying. When this reply will cost, it will have a statement of whatever the statement he is making about the opposition and the evidence. Again, he will send the copy to applicant. Then comes the third part. Then is the further evidence. So see, two people have given the evidence. First, in notice you gave something evidence. Applicant contested, you gave evidence. Then opponent sees that whatever I have claimed, applicant is claiming something different. So he will give additional evidence if possible and then submitted. A copy to applicant has been sent. Generally, reply to opponent is by 1 month, and within 2 months, applicant has a 2-month period to respond to the notice. These are the in general timelines. And once it is done, the further evidence will leave to controller. What happens is, if anyone wants to submit evidence now, he needs the permission of controller. That is what it means, that further evidence can be submitted with leave of controller. Leave means permission. That further evidence with leave of the controller. Okay. Then compilation or presentation of evidence will happen. In this, a notice of hearing will be sent. Notice of hearing 10 days, at least 10 days prior to the notice of hearing, this notice of hearing has to be sent. Okay. The hearing, suppose hearing is to be on 15th October, you have to give 10 days at least for other party. Notice should be at least 10 days before. That means your notice should be received by him on 4th October or 4th October, right? 15 को 4th को दे दिया, done. 10 days पूरे हो गए. Notice to be heard and plus fee. So there are certain places where it says hearing is only on the request. If you request, then only. So you have to tell every time in writing that I should be given an opportunity to hearing before the issue is decided. Now comes new publication to be relied on in hearing only with 5 days. Suppose. So now suppose you found something that I want to publish, there is this new publication I want to write. This is a new thing. Then only with 5-day notice, you have to give this publication to controller and other party, and this has to be shared at least 5 days before the hearing. Otherwise, in hearing, controller will not be able to consider it. Once it is done, hearing is done. After that, in front of a controller, hearing is done. Both parties present their argument, argue their cases, and on the basis of the hearing, controller makes a decision and then notifies the decision to the parties involved. This is a general format in which this is happening, where it is applicable. All these 6 places, it will happen like this. Post grant opposition, a minor change will be there, that there is a constitution of an opposition board, but post grant opposition under section 25(2) will work like this. Mention of an inventor under section 28 will work like this. Directions to co-owner 51 will work like that. Amendment of application or patent, if there is a proceeding under 57, this will work like that. Opposition to restoration 85, and surrender of patent 86. So this is the general format in which a proceeding works. Tomorrow we will discuss how the pro-grant opposition and post-grant opposition works, and how the wrongfully obtained invention, if there is, what is the specific case and how do we work in the opposition proceeding. Then comes 52, that is a grant of patent to inventor obtained by fraud, how that works. Okay, so all this with mention of inventor as well as everything else, amendment and other thing, we will be discussing it tomorrow. Tomorrow, 7 to 8.